Who is held responsible in a hit-and-run accident?
The attorneys at Fenstersheib Law Group explain.
In a criminal case, the driver of the involved vehicle is the responsible party. If the driver is not the owner of the vehicle that he was driving when the crash occurred, only the driver is criminally liable. An exception would be if the driver and owner of the vehicle were both breaking the law at the time of the hit-and-run accident, such as if the owner of the vehicle knew that the driver was uninsured or under the influence, but still allowed him to operate the vehicle. In cases like that, both parties would be liable for the accident. Responsibility in a civil case is a little bit different. In a civil case, the driver and the owner are both liable for damages, even if the owner of the car was not driving when the crash occurred. His ownership of the involved vehicle alone makes him liable for at least part of the damages. This is also true of on-the-job accidents. If the offending driver was driving a company car, the owner of that company would also be liable. The extent of liability of the non-driving owner in an auto crash depends on numerous factors. Some of these factors include whether or not the owner allowed an unlicensed or uninsured driver to operate his vehicle, whether he knew if the driver was under the influence and yet still allowed him to drive, or whether he knew the driver had an unclean driving record. In those cases, allowing the driver to operate his vehicle would be considered negligence. Some exceptions apply, which can absolve the owner of liability for damages incurred in a hit-and-run, such as unauthorized use of the automobile or car theft.
For a free phone consultation, contact attorneys at Fenstersheib Law Group, PA in Hallandale Beach, Florida today. With the right legal team behind you, Fenstersheib Law Group, PA will fight the system with you to get the compensation you are legally entitled to.